My name is Emma Manea and I'm the Manager of Professional Development for Crime at Legal Aid. I'll be delivering a series of training modules which are aimed to assist you to best represent legal aid clients. It is hoped they will provide you with the tools you need to do the work for our clients who are disadvantaged, who suffer from mental health issues, come from non-English speaking backgrounds and are DV victims or Aboriginal and Torres Strait Islanders. To assist our clients, we must remain mindful of the way we communicate with them. Clear, concise and accurate communication delivered in an empathetic way will ensure that our clients are able to understand what is happening with their matters at all stages of the process. This first module is Summary Crime and will be part 1 in a 2-part series. This will cover eligibility for legal aid in summary matters, bail, sentencing, hearings and Section 32 and Section 33 applications. As part of each module, you'll also be referred to other resources like podcasts, recorded webinar videos, and also written papers. You should view all video material in this summary part module 1 in full and then refer to those resources. A complete list of those resources will be made available to you. After viewing this module, you will have an increased knowledge of the essential framework to undertake a summary matter in the local court and appear for our clients. The first topic area covers whether a person is eligible for legal aid. The relevant policies are available to you through the resources link. Legal aid provides representation in summary matters for certain types of matters where aid is available and for applicants who satisfy the means test. In criminal proceedings in the local court, legal aid is available in bail applications, criminal charges except traffic matters, and where the offence carries a term of imprisonment as a penalty or there are exceptional circumstances. Exceptional circumstances include where an applicant is at a special disadvantage, such as the applicant is a person who has substantial difficulty in dealing with the legal system by reason of a substantial disability or condition, or the applicant is a victim of domestic violence. Where a plea of not guilty has been entered, to obtain legal aid for a defended hearing, the applicant must satisfy certain tests, including that there is a real chance of them receiving a term of imprisonment or there being exceptional circumstances. This means a prospect of going to jail or getting an intensive correction order. Exceptional circumstances include where the applicant is at a special disadvantage, where the matter raises an issue of civil liberties, where the matter involves the death of a person, they are under the age of 18 years, or they are a victim of domestic violence, or other circumstances. Other areas we act for people in a very limited way are in driving and traffic offences, however also only if they're likely to go to jail or there are exceptional circumstances. Legal aid also acts in annulment applications, known as Section 4 applications, where there is merit and it falls within our policy. See Legal Aid policy for further information about other matters where legal aid is available. As we know, bail is the authority to be at liberty for an offence or an alleged offence, and it allows a person to be at that liberty when they are required to be before a court. When arrested and charged, the police can release a person with or without bail conditions. If the police decide not to grant bail, the accused must be brought before the court as soon as practicable. The local court must hear a release application, as it's referred to in the Bail Act, but we commonly call it a bail application, on the first day that the matter is before the court. A magistrate or registrar hears the application. Usually registrars only preside on the weekend at bail court, but this may vary across the state. The following slide will contain a basic flowchart of the test the court is required to apply for bail, and this flowchart reflects the real application of the Bail Act in practice. It doesn't include offences for which there is a right to release under Section 21 of the Bail Act. This includes offences where the maximum penalty is a fine, and most summary offences that do not involve violence, weapons or obscene exposure. It is rare that these people would be brought before the court. It's important to note that the rules of evidence do not apply to release applications. The court really must take into account any evidence or information that they consider credible and trustworthy in the circumstances. Any determination is to be made on the balance of probabilities. Practically speaking, this information will come from the lawyer appearing for the accused person. It sets out their background. Perhaps they will have an opportunity to call a proposed surety or a person that they're going to be residing with. The court is interested to know about if the person works, where they live, where they will report to at a police station, if they have any community supports or community ties, need any medical attention or any other matters that are relevant to that person. It's worthwhile asking your colleagues about the magistrate's view on these issues, as it will really save you time in the long run. We have provided you with an instruction sheet about the types of information you should ask and the things to look out for in the criminal record. Show cause. There are certain offences and situations where an accused is required to show cause why their detention is not justified. That means that the onus and responsibility is on the accused to satisfy the court on the balance of probabilities. If an accused person is not charged with one of these offences, then they need to convince the court that they are not an unacceptable risk of failing to attend court for the offence, committing a serious offence, endangering the safety of the community or victims, or of interfering with witnesses. The offences and situations where an accused person are required to show cause are set out in Section 16B of the Bail Act, but include very serious offences and offences carrying 5 years or more imprisonment when the accused was already on bail, was on parole or subject to an arrest warrant. The Bail Act has not set out what circumstances amount to show cause. The most helpful authority is set out in Mulcahy and the DPP, which summarises the key authorities, and those are provided in the attached resources. 6 key points from that case include: it is a separate question to whether there would be an unacceptable risk. Parliament has not defined the facts which may show cause, in contrast to the factors defined as relevant to unacceptable risk in the Bail Act. There will be a substantial overlap between factors that may go to whether cause has been shown and the factors which inform whether an unacceptable risk exists. Cause may be shown by a single powerful factor or a powerful combination of factors. One should refrain from placing a gloss over the words of the Bail Act. In particular, it's not incumbent upon an applicant to show special or exceptional circumstances in order to show cause. See Section 22 of the Bail Act. One can find countless examples whereby a single judge of the Supreme Court has found that an applicant has shown cause or failed to do so, because many bail decisions are evaluative judgments about the interplay of a multitude of factors. They're not determinations of legal questions. If you are aware of these above principles, then you'll be well armed to deal with a show cause release application. It is on the defence to satisfy the court, so the prosecution will usually not consent to bail being granted for a show cause offence, and the police will not grant it themselves. When making submissions, it is ideal to try and deal with both the concerns and the show cause aspect at the same time as much as possible, as while they are separate tests, there is often substantial overlap between the two tests. What are bail concerns? There are 4 concerns identified in the Bail Act that must be considered in making a decision. The court is concerned with determining if the accused is granted bail, will they fail to appear at any proceedings for the offence, or commit a serious offence, or endanger the safety of victims, individuals, or the community, or interfere with witnesses or evidence. If there is an unacceptable risk of one or more of those occurring, then the court must refuse to grant the accused bail under Section 19. This is what is referred to in the Act as the unacceptable risk test. Practically speaking, properly drafted conditions for a person who would normally be an unacceptable risk could allow them to be released on bail with the imposition of these conditions. So, the imposition of adequate bail conditions can mean that what would normally be an unacceptable risk will mean that the person's released. You should have a set of suggested bail conditions to propose to the court as part of any release application. Section 18 contains a very exhaustive list of the matters to be considered in the assessment. This is attached in the resources. A suggested outline of submissions for any release application is also provided to you. We've broken down each of the bail concerns and what are suggestions of factors identified in Section 18 of the Bail Act that are relevant to those concerns. If you are prepared in this way and the magistrate says, "I'm concerned about the risk of failing to appear at a future date," then you'll be able to answer that question. The second is a sample of instructions that would be helpful to know for any bail application. Be mindful that there are limitations on imposing bail conditions, and these are set out in Section 20A. Your client gets one bite at the cherry if you represent them. They can only make one application for release in the local court unless next time they can show that new information has come to light or there has been a change in circumstances. If they represent themselves or a registrar heard their first application, only then can they have another go. Detention applications are different. If the prosecution asks for bail to be revoked, usually it is not a release application, so the prohibition in Section 74 of the Bail Act does not apply and would mean the accused person is able to make a further release application before the local court. The right of appeal from the local court is the Supreme Court, and it is conducted by way of rehearing, and the same principles apply, however it's more formal. This will be covered in the next summary module in Part 2. Sentencing in the local court is a daily occurrence. In order to represent legal aid clients effectively, the following information hopes to guide you on how to prepare and how to appear in a local court sentence matter. At the outset, it's useful to approach a sentence matter in the following way. Firstly, obtain your client's instructions. It's often said by us lawyers, "I would have the perfect plea without any instructions from my client." However, this is essential and it forms the basis of your structure for a sentence. Obtain instructions in writing and make sure they are signed and dated by the client. This is not only to maintain proper file notes, but it also preserves your own professional and ethical position when appearing for clients. So, what should you include? A list of the actual offences with the sections for each offence is a starting point. Attached to the signed instructions, a copy of the facts they are pleading to. The client should sign and date a copy of the facts. This will be for your file only. This ensures they are agreeing to what the circumstances are of the offending, and there can be no mistake at a later stage. Include the relevant discount for a plea of guilty and outline any possible defences that the client may have had available to them and why they're not defending the matter and they decided to plead guilty. Cover the reason for pleading guilty. For example, does the client admit the offence or is it a plea of convenience? And make it clear that it is their decision by including the line, "I make this decision to plead guilty of my own free will, and I sign and date these instructions to indicate that I have read and understood them, and I instruct my solicitor to plead guilty." State that you've made them aware of the possibility or likelihood of jail and the likely penalty. Outline the maximum penalty for the offence and if the person is likely to receive a term of imprisonment as a penalty. A combination of your own past experience, your knowledge of the client's subjective case, the facts of the case, the magistrate, and any other information you can rely on, like jurors' statistics, can all assist you here when advising your client on the likely penalty. It is best practice to base your advice on these factors and be conservative. Emphasise that this is a guide. It is better to have a client who is prepared by the advocate appearing for them for a jail penalty of a longer duration rather than a situation of being surprised that they even get to go to jail. Setting realistic expectations here is both professional and ethical. You do not have a crystal ball. You can't predict the future. However, you can base your advice on all this data as well as statistics from jurors. The next aspect to consider in preparing a sentence matter is any subjective material, including any reports. What should you tender and why? This will depend completely on the subjective case of your client. It is essential that any document you tender has been given to the prosecution with reasonable advance notice. You get more from a magistrate if you make their job easier. Reports should be copied with the original report, if possible, tendered, and a working copy for the magistrate to mark, should they wish to do so. Make sure that any expert reports are signed and dated and have an outline of their expertise in the attached short CV. If you have time, it's best to present an index of the material, including any references. A referee must state that they are aware of the offences and that they have read the statement of facts. We have attached a useful reference guide in the resources. Check you have everything: an up-to-date conviction report or a redacted bail report, any breach reports, the SAR, Sentence Assessment Report, which is the new name for the old pre-sentence report. And the purpose of this report is to assist a sentencing court to determine the appropriate sentencing options and the conditions to impose on the offender. A magistrate can request a general assessment report addressing suitability for multiple or various conditions, or just for a particular type of condition alone, for example, community service work. Duty assessment reports provided at court on the same day will still be available at certain courts. A SAR will often include how offenders' behaviour and risk of reoffending would be addressed by supervision, any conditions that would facilitate effective supervision in the community, your client's suitability, a summary of their previous response to supervision, and anything else like if they are suitable for home detention. Look out for prejudicial and/or inadmissible content included in SARs. Under the title of History of Antisocial Behaviour and Attitudes, topics have the potential for inflammatory material to be included. So remember, you can object to portions of this report and require the writer to come to court for cross-examination. Or you can just write an email to the manager of the report writer and ask for this to be addressed. There are situations where the court must request for a SAR to be done. Unless those apply to your client's case, a sentence can proceed without obtaining a SAR. When imposing an ICO, home detention, or community service work, you need a SAR. With home detention, a term of imprisonment must be set first, then a SAR is done to cover their eligibility. Ultimately, there are 3 things that the court wants to know: what happened, objective circumstances, why it happened, subjective circumstances, and why it won't happen again, prospects of rehabilitation. It's important to have a flow in your structure with a beginning, middle, and an end. Each practitioner has their own advocacy style. However, it's important to remember your audience. Often magistrates will hear hundreds of pleas of guilty per week in a busy court, and as an advocate, it's your job to persuade the magistrate to deal with the case in a way that's most favourable to your client. Simple. The start of the plea is when you have a captive audience. It's the best time to harness the attention of the magistrate. It should be direct, punchy, engaging, and efficient. At the beginning, think about if there's something you can hang your hat on. Is there a theme? Your tone should be neutral and not emotional. Your content should be concise, so don't repeat yourself. Your delivery should be structured, logical, and dynamic. Your ultimate submission, what you say the court should do to or with your client, is often a good place to start. If you can ask your colleagues to find out prior to appearing what the preference of the magistrate is, then do it. It's important to know your bench when pitching a reasonable type of sentence or duration of a jail penalty. Stick to your guns, but don't assume they know what you are asking for. Lack of preparation at this point could aggravate rather than persuade the bench. In the middle of the plea, you should go through the objective circumstances and objective criminality. Tell the magistrate where this offending sits in the range. It is important when the court considers all the other assault matters that day, week, or year which come before them. Provide context to the offending. You should consider and unpack the surrounding circumstances to the offence. State the timing of the plea. This is relevant in two ways. In terms of the person's willingness to admit their guilt, which can be connected to their prospects of rehabilitation, as well as the time it saved the court in adjourning and listing the matter on several occasions. Mention their criminal history only if it's before the court. The prosecutor has a duty to advise the court of your client's record, not you. Address what your client's record says about prospects of rehabilitation and the possible appropriate penalty. When you address the subjective case, consider if the Bug Me principles apply. You'll find a link to a webinar about the Bug Me Bar book in the resources, and it contains chapters summarising key research relating to experiences of disadvantage and deprivation. The purpose of this resource for practitioners is to assist in the preparation and presentation of evidence to establish the application of the Bug Me principles. Outline to the court any efforts made by your client at rehabilitation after the offence. Is your client working or seeking to address their substance issues? Have they done drug urinalysis testing, or are they regularly attending DNA counselling or therapy and/or courses? In wrapping up, state the appropriate disposition and why. Tell the court how it all fits together to lead logically to what you're asking for. As former senior public defender, now district court judge, Peter Zara SC said, land the plane on the tarmac. Outline why the sentence you're proposing strikes the balance between all of the purposes of sentencing: denouncement, retribution, and rehabilitation. Now for a few important tips for after the sentence hearing. Make sure you take the time to speak to your client. Explain what the result is and what it practically means for them. If the client gets a sentence that is excessive, explain the sentence and the appeal options and get instructions about lodging an appeal and appeals bail if relevant. Note that you cannot apply for bail unless the appeal is already filed. If community-based orders, make sure you explain their obligations and also advise them about their appeal rights. But note there is limited eligibility for legal aid here. You will now see on your screen a very useful slide which contains a table, which is a cheat sheet of the current sentencing regime. It's my go-to document when appearing in a local court, and this is also contained in the resources. Section 3A sets out the 7 purposes for which a court may impose a sentence on an offender, and these are going to be at the forefront of the sentencing magistrate's mind, so they are important matters to prepare and present in your plea. These purposes can be used as a good checklist for every time you prepare a sentence. Firstly, to ensure that the offender is adequately punished for the offence. Secondly, to reduce crime by deterring the offender and any other persons from committing similar offences. To protect the community from the offender. To promote rehabilitation of the offender. To make the offender accountable for his or her actions. To denounce the conduct of the offender. To recognise the harm done to the victim of the crime and to the community. These areas provide a useful framework to present the sentence. It is important to mention if the Section 5(1) threshold is satisfied, because this provision reflects the common law principle that imprisonment should be used as a last resort. It says that the court must not sentence an offender to imprisonment unless it is satisfied, having considered all possible alternatives, that no penalty other than imprisonment is appropriate. In sentencing, the relevant law is attached to the resources. However, the following acts and regulations are relevant: Crimes Sentencing Procedure Act 1999, Crimes Administration of Sentences Act 1999, The regulations being Crime Sentencing Procedure Regulation 2017 and Crimes Administration of Sentences Regulation 2014. It is important to know the sentencing options, and the flowchart that you can see now shows these options. A CRO stands for Conditional Release Order, and a CCO is a Community Correction Order. There are key features, a CRO and a CCO, which can be found in the sentencing reform resources attached to this video. An important change with an ICO is that community safety is now the paramount consideration for the court when deciding whether to make an ICO. It requires the court to assess whether an ICO or full-time imprisonment is more likely to address the offender's risk of reoffending. Community safety is not just about incarceration. Imprisonment under 2 years is commonly not effective at bringing about medium to long-term behaviour change that reduces reoffending. Evidence shows that community supervision and programs are more effective at this. There are standard, additional and further conditions for ICOs, and it is important to be aware that there are excluded offences and see the legislation for more. Offences for which an ICO cannot be imposed: prescribed sexual offences, defined in subsection 2, offences involving contravention of a serious crime prevention order, offences involving contravention of public safety order, offence involving discharge of a firearm, an offence that includes commission of or intention to commit one or more of those offences, an offence of attempting or conspiracy or incitement to commit one or more of those offences. It's important to know that a court cannot impose an ICO for DV offences unless satisfied that the victim and any person with whom the offender is likely to reside will be adequately protected. A court cannot impose home detention condition for DV offence if the court believes that the offender will be residing with the victim. Breaches of an ICO are dealt with by community corrections, and the legislation outlines what actions can be taken in respect of those breaches. Breaches will often then result in revocation. You'll be provided with a link to other important resources for sentencing. My top tips for advocacy are: be concise. Tell the bench how long you will really expect to take. Know your bench. Maintain your credibility. Concede what you need. Steal your opponent's thunder, but no court drama. It's not necessary here. Try to find that hook to hang your submissions on, and then develop a logical and cohesive theme based on it. Be realistic about the likely outcome and sentence, and make sure your client is aware of this. It shouldn't come as a complete surprise that your client gets an excessive sentence from the courtroom floor because you'll already have told them and prepared them for this possibility. Remember that you're not a magician, and never, ever start your plea with, "My client is a 24-year-old male." This is both lazy, and it will get the bench offside when you have your captive audience. Use your 5 minutes of fame effectively and get what you want for your client. There are several ways to approach a defended hearing, and each advocate will have a different style and manner. The purpose of this module is not to discuss, other than briefly, the substantive criminal law or practical aspects of advocacy. The acts that are referred to throughout this module are the Crimes Act, the Criminal Procedure Act, and the Evidence Act. You should also consider the policies and guidelines of legal aid that may be relevant to their particular matter. For example, the Defended Hearing Policy and Jurisdiction Test, which you can locate in the linked resources. So what do you do first? Look at the charges which are contained in the CAN, Court Attendance Notice. These set the parameters of the charge against your client. It should state the act, matter or thing alleged as the foundation of the charge. For example, in a charge of larceny, the property must be identified with precision, as should the date or range of the alleged theft. If the can does not include the particulars, then your client will have difficulty understanding the exact case to answer. Write to the OIC to request further and better particulars, and do this as early as possible. When you know the exact conduct, you can then start to research the offence, analyse the evidence, and take detailed, targeted instructions from your client. Next, you need to look at what the prosecution case is, and this is found in the brief of evidence. The prosecution is required to serve the brief of evidence on the defence before a matter is set down for hearing. Certain summary offences are exceptions to this rule. DV offences require the prosecution to provide the defence with a mini brief on the first mentioned date, and the matter is adjourned for a defended hearing as soon as possible. The law states the brief should include written statements taken from people the prosecutor intends to call and copies of any documents or any other thing as a proposed exhibit. The brief of evidence will usually include statements from police, the statement of the victim, statements of civilian witnesses and of expert witnesses, results of forensic tests such as alcohol tests, and any photographs, plans, sketches, and other similar documents. Make sure that you always check that the statements have been signed and dated and that any expert certificates comply with Section 177 of the Evidence Act. The next step is to analyse the evidence. Identify the elements of each offence, and these are the individual components or ingredients of an offence, and the prosecution must prove each element beyond a reasonable doubt. A clever way to analyse whether the elements of an offence are established is to divide a page into two columns. Label one column the elements of the offence and the other the evidence. Write down each element of the offence in the left column, and in the right column, note the evidence in the brief that relates to each particular element. This will allow you to see what, if any, evidence exists for each element, and whether there is a prima facie case. The nature of that evidence, is it direct, circumstantial, etc., and the quality and reliability of that evidence. Next, consider if there is a prima facie case. This requires there to be admissible evidence in relation to each element of the offence. Concern yourself with whether there is simply evidence for each and not the quality of it at this stage. No evidence for one or more element of the charge, then the offence cannot be proven. You should now turn your mind to the strengths and weaknesses of the prosecution case, so analyse the quality of the evidence. Working off the same table as I described earlier, closer analysis should be applied to each particular piece of evidence. Once you've done this, you need to think about if there are any defences available to your client. So, for example, with a larceny offence, is there a claim of right? With a charge of assault and affray, can you raise self-defence? The prosecution is under a continuing obligation to make full disclosure in a timely manner of all material known to the prosecutor, which may be relevant to a fact in issue. I refer you to the DPP guidelines and particularly Guideline 18. It is generally, but not strictly accepted, that these prosecution guidelines apply to police prosecutors. A useful webinar that discusses the case of Bradley and prosecutorial disclosure is included in the resources. The webinar and the attached documents are part of the webinar, and they are excellent resources on this topic. Now consider if you need further information. Often there will be additional details that are referred to in a witness statement but which are not in the brief, like photos, diagrams and sketches. Write to the OIC and copy in the senior police prosecutor at the relevant court or police station. You might ask for the criminal records of the victim or other relevant witnesses, applications for search warrants and listening device warrants, custody management records, and other documents that are referred to in the brief but are not in it. The provisions relating to requests are contained in sections 166 to 169 of the Evidence Act. Material that might not have been provided by the prosecution can be obtained by subpoena, like CCTV footage, criminal histories of prosecution witnesses. Sections 220 to 232 of the Criminal Procedure Act relate to subpoenas. Remember, once you issue a subpoena, the material will be accessed by both parties, so be sure you are happy for whatever is produced to be accessed by the prosecution. If you have determined that the prosecution case is deficient or too weak to convict your client, make sure you explain this to your client before you get their version. This is important in terms of your ethical position. Once you have agreed there is a case for your client to answer, you can take detailed instructions, which is their version of the event, what they say did or did not happen, their comments on the victim and witness statements, their comments on the arrest, charging, detention and interviewing, and lastly, if there are any witnesses they would call in the defence case. You should always get your client to sign instructions for your file. Then consider if their instructions reveal a defence. Your client may deny the allegation altogether, dispute certain facts alleged in support of one or more elements of the offence, raise a defence at law, or seek to put the prosecution to proof. There are a number of legal defences such as duress, necessity, claim of right and self-defence. Strictly speaking, not all of these are defences, but are matters that, once raised, the prosecution has to prove beyond a reasonable doubt where not present in the particular case. If you have a defence witness, take a detailed statement from them. Ensure they read and sign their statement. Subpoena your own witnesses, even if they tell you they'll be coming to court to give evidence. Evidence of good character can be led for two reasons, and the provisions relating to evidence of good character are in sections 109 to 112 of the Evidence Act. Prepare by working in reverse and formulate a case theory that is consistent with the plea of not guilty. If you cannot arrive at this, your client should probably be reconsidering their plea. Your case theory is the nub of your closing address, which is the first thing you should prepare. The reason for preparing the closing address first is that it highlights the crucial issues in your case, such as the weaknesses in the prosecution case, any statutory or legal defence, what evidence you will have to lead from particular witnesses, your areas for cross-examination, objection, and re-examination of defence witnesses, and the case law that's relevant and supports your case. Maintain a degree of flexibility when drafting your closing, as anything can happen when the evidence unfolds. For each prosecution witness, prepare a table with a column that summarises their statement, a column of objections to their evidence, and a column for cross-examination points. Each cross-examination question should have a purpose, informed by your case theory and in support of your closing address, to either discredit damaging evidence or to highlight favourable evidence. You need to prepare your client. This doesn't mean coaching them, but it does mean explaining to them how to listen, think, and then answer questions precisely. Really difficult to do. Explain to them the constraints of examination in chief. You have to ask non-leading questions, the risks of cross-examination, and the purpose and limitations of re-examination. Thorough preparation will include a detailed chronology of the matter, including events leading up to the incident and the events afterwards. It can be useful to incorporate relevant parts of witness statements in a chronological order. Sometimes a view of the location where the allegation is said to have occurred can be invaluable. By doing this, you will gain an appreciation of the lighting, any visual obstructions, and distances between crucial points in the surrounding area. Will you use exhibits? These do enhance the impact of oral evidence and can be very important. They can be diagrams, models, maps, photographs, actual objects, and audio and video recordings. Make sure you watch any ERISP. The recording is an exhibit when it's tendered in court. The transcript of the recording is an aide-memoire. It assists the court, but it's not the actual exhibit. You can cross-check the transcript for accuracy and observe your client's manner and condition at the time of questioning, so it's important to view the ERISP. Speak to the prosecutor before a hearing and clarify any parts of the prosecution case you're unsure of. This will help you identify issues in dispute and not in dispute, to check how the hearing will run, and to ensure that any inadmissible evidence is not led. There is no property in a witness, so this means you're entitled to speak to prosecution witnesses if you choose to, but you should exercise caution in doing so. Speak to the officer in charge of the case as well as the prosecuting officer or solicitor first. If that witness is legally represented for a related issue, you should approach their lawyer first. Always have an independent witness, not your client, with you when you speak to them. Better still, consider speaking to them only in the presence of the prosecutor or the OIC. Refer to the Law Society for guidelines in relation to contact with complainants in apprehended violence orders and family violence matters. Always consider speaking to a prosecution expert witness to discuss how they arrived at their opinions. This information will help you in preparing the case, and particularly in your cross-examination. Police and prosecutors often serve additional brief items within 14 days of the hearing date, and even on the day, and you can object to this evidence because it wasn't served within 14 days. The court can allow the evidence in despite your objection, or the court can adjourn the proceedings. Both the Criminal Procedure Act and the Evidence Act contain a number of important sections relating to the taking of evidence from witnesses, and you should be fully across this legislation. Courts often overlist matters, so be ready. When you start, the magistrate may ask the parties, "So what is this matter about?" or ask for an opening address. This is your opportunity to outline the issues that are and are not in dispute, and when the prosecutor has to state their case. The magistrate may also say, "Call your first witness, Sergeant." The prosecution goes first and usually starts with police witnesses, the complainant, civilians, and then the expert witnesses. At the close of the prosecution case, you have an opportunity to address the court. Then you proceed with the defence case and calling your client and other witnesses. When the defence case has closed, then the prosecutor makes their closing address, arguing why your client should be convicted. You then make your closing address, which you will have already sketched out long before the hearing began. A more detailed analysis on how to approach and prepare defended hearings is contained in a comprehensive paper linked to this video in the resources page. What to challenge in the prosecution case and excluding evidence, admissibility of evidence, unlawfully or improperly obtained evidence, the rule in Brown and Dunn, and why it's important to put your client's instructions in questioning is covered in this paper. The paper will also cover what you need to think about when deciding the big question, to call or not to call your client, and the ramifications of each. Make sure you take thorough notes of the evidence and make effective objections. Be organised. We've all seen that practitioner that is constantly shuffling papers across the bar table trying to find a document. Don't be that practitioner. During your examination in chief, it's best to work from your client's typed instructions so you can check off the issues and facts as you go along and make sure you don't miss anything. During your client or witness's cross-examination, you may write their evidence on the side of the column and any re-examination points on the other side. Maintain a list of the exhibits and refer to them when speaking by their number to make it easier for the transcript. Have a comprehensive knowledge of the Evidence Act and the grounds for objection contained in it. I object. This is where the vibe comes in, and you need to really trust your instincts. If evidence sounds or seems objectionable to you, then it probably is. So object to it and then formulate the grounds. If the evidence is in fact not objectionable, just withdraw the objection. Heading of the most common grounds for objections can assist you in determining the basis for the objection. Some of these grounds are relevance, hearsay, and opinion evidence. You will have also prepared a table of prosecution witness evidence, in which you will have already identified potential objections to that evidence. Say what you mean and mean what you say. Begin your objection with a direct explanation of the objection, such as, "This is hearsay evidence because," or "This is not relevant evidence because." There are a number of practice notes relevant to hearings in the local court. These can be found in the relevant resources. You must be aware of the practice notes and adhere to them. The advocacy rules apply to all solicitors who appear as advocates in court. The rules are linked in the resources page. The rules refer, amongst other matters, to the efficient administration of justice, the duty to the client, frankness in court, the integrity of evidence, and the duty to the opponent. The final topic in the Summary Part 1 module is about Section 32 and 33 applications in the local court. This is a practical guide on the operation of these sections. The relevant act is the Mental Health Forensic Provisions Act 1990, New South Wales. These provisions exist to divert an accused person from having their matter dealt with in the criminal justice system. If the client is not diverted or otherwise dismissed, then you will need to consider the principles guiding the sentencing of offenders with mental health conditions, and this will be dealt with in the next training module summary part 2. Comprehensive papers are available to you through the resources link. Section 32 applies if you have a client in a summary criminal matter who falls within the following class of persons, either at any time throughout the proceedings or at the time of the commission of the alleged offence: a cognitively impaired defendant, a defendant suffering from a mental illness, or a defendant suffering from a mental condition for which treatment is available in a mental health facility. Defendants who are currently mentally ill within the meaning of the Mental Health Act 2007 are ineligible for diversion under Section 32. A magistrate may inform themselves as they see fit, and the types of evidence you need to make a 32 include reports from a Justice Health clinical nurse consultant and reports from the defendant's treating doctor, psychologist or psychiatrist. These reports are considered more closely in the resources. The legal test for the application of Section 32 is that there are 2 limbs to the test prescribed, described as a 2-fold test in DPP and Elmawas, 2006. The first limb is essentially the threshold question of whether your client falls within the class of persons that make them appropriate for diversion under Section 32. The second limb is discretionary, and it involves the magistrate deciding whether it's more appropriate to divert the matter under Section 32 or deal with it in accordance to the ordinary criminal law. The New South Wales Judicial Commission Sentencing Bench Book sets out the following factors that can inform the exercise of the discretion: seriousness and circumstances of the alleged offence, defendant's criminal history, existence and content of a treatment plan, limited period of 6 months that conditional orders are enforceable by the court, and sentencing options that are available in the event that the defendant is dealt with according to law. You should present a treatment plan with a diagnosis. The treatment plan will assist on the discretionary limb, deciding whether it's more appropriate to divert the matter under Section 32 or deal with it in accordance to the ordinary criminal law. The diagnosis will provide the grounds for the court to deal with your client by way of Section 32. Clinical nurse consultants assess clients in custody when they first appear after being bail refused by police, but also for those on bail. They are able to get information from other mental health treatment providers and provide succinct reports to the court about whether Sections 32 or 33 apply in a particular case. They are good for legally aided clients where there are limited resources to obtain private reports. On the downside, these reports frequently and inappropriately comment on the discretionary second limb. This is advantageous when the recommendation is that it's appropriate to divert the matter. Another way to get the treatment plan before the court is through expert reports. When engaging experts, you must firstly take a thorough history from your client and obtain relevant records under authority. Some examples of this include discharge summaries from prior psychiatric admissions, psychological and psychiatric reports for previous matters, Medicare mental health plans, community mental health team records, and justice health records. Remember, your client does not have to enter a plea before making a Section 32 application. The types of orders that can be made are interlocutory orders or final orders. A Section 32 order can be enforced. If the client does not comply within 6 months of the order being made, they can be called up to appear before the court. If the defendant fails to appear, then a warrant can be issued for their arrest. If the application is refused, the matter proceeds according to the ordinary criminal law. So make sure you take instructions about either pleading guilty or defending the charges. Section 33 applies if your client is mentally ill at the time they are before the magistrate, and unlike Section 32, it's not concerned with their mental state at the time of the alleged offence. Section 33(1)(a) allows a magistrate to order that a defendant be taken to and detained in a mental health facility for assessment. An order under this section does not mean the court no longer has jurisdiction to deal with the charges unless 6 months have gone by before the person returns to court. Section 33(1)(b) allows for the accused or defendant to be taken to and detained in a mental health facility for assessment and be brought back before the magistrate if the defendant was found not to be mentally ill or a mentally disordered person. Again, this doesn't end the matter unless 6 months have gone by before they return. Section 33(1)(c) allows for conditional or unconditional release into the care of a responsible person. Section 33 is often used when a person is noticeably unwell. Reports from clinical nurse consultants are often relied upon as a basis for making an order. That's all for Summary Crime Module Part 1, and be sure to check out Summary Crime Module Part 2.